se impairment.
Drugs of abuse, I'm sorry, drugs of abuse is what I meant to say, Your Honor. There are per se limits for certain drugs, per se limits for alcohol. However, methadone is not scheduled in that manner. There's been no testimony by any witness that methadone is in fact a drug of abuse. In reality, what we did have was Dr. Franklin testify that methadone is not a drug capable of impairing an individual in any way, and there's been no indication that methadone is anyhow abused by folks. Given those things, Your Honor, I'm going to ask that this court grant a judgment of acquittal on count 5, and then by extensions to count 1 and 3.
Thank you. On behalf of the state?
Yes, Your Honor. In regards to that motion, Your Honor, the state will request it denied. The facts still have to be viewed in the light most favorable to the non-moving party. And it seems the only thing at issue, or what defense counsel is attempting to challenge, is whether or not methadone is a drug of abuse. As defined by the courts, and as will be defined in the jury instructions, a drug of abuse means any controlled substance, any harmful intoxicant, and any dangerous drug. And so the state will submit that there has been more than enough testimony regarding methadone being a controlled substance and a dangerous drug. And that was testimony given through various witnesses, Your Honor.
Let's stop, because this is a really technical argument, and I didn't bring this up to the parties lightly, all right, because I understand the situation involving the trooper is tragic, and everybody has worked very hard on behalf of their clients, all right? But this is a very technical issue, and it's one that only came up because of an offhand remark by defense counsel the other night. And when I was driving home, I thought, all right, well, they're asking for a definition in the jury charge of drug of abuse. And so Saturday I spent a lot of time going over every aspect of the potential jury charge, all right? So we're dealing with count 5. And the issue is when at the time of the operation, he, being Mr. Gaspar, was under the influence of alcohol. Do we have evidence of that?
No, Your Honor.
All right, so alcohol, a drug of abuse, or a combination of them. Well, I thought from the urine and from the blood there was no evidence of alcohol.
Correct.
So now we're only dealing with whether he was under the influence of a drug of abuse. And I would, for purposes of sentencing charge and all, I would have put in to it methadone. But going back to the statute, 451119A, I'm sorry, 4511.181 definitions. Subsection E says, drug of abuse has the same meaning as in section 4506.01. Do you have that pulled up?
We're pulling it up now, Your Honor.
So, it's a term of art. It's a defined term, drug of abuse, and it's in quotes, has the same meaning as in 4506.01. This is why I wanted the parties to look at it yesterday.
Yes, Your Honor. And in addition to those arguments, though, Your Honor, we also believe that 4506.01 still defines drug of abuse as any controlled substance, dangerous drug, as defined in 472901, or over-the-counter medication that when taken in quantities exceeding the recommended dose can result in impaired judgment or reflexes.
I'm sorry, where are you going?
This is 4506.01M, Your Honor.
Yes, and that's exactly where I'm at, okay? Under subsection M means any controlled substance. So when you go to 3719.41, Schedule 2, and then it has under B, narcotics, opiates, 15, methadone. Do you want me to repeat?
Could you please, Your Honor?
Yes. Controlled substances under 3719.41, Schedule 2, under B, narcotics, opiates, subsection 15 is methadone. Okay?
Okay.
So then that takes me back to drug of abuse means any controlled substance. So that would include methadone. A dangerous drug is defined in section 4729.01. So we'll have to look at that. Or an over-the-counter medication. Well, this is not. This is he obtained a prescription or had a prescription. This is not like he took an over-the-counter allergy medicine or something.
Correct, Your Honor, but under 4506.01M, drug of abuse means any controlled substance. So methadone is covered under controlled substance, which you just recited from 3719.
But there's a qualification.
Cool.
Drug of abuse means any controlled substance, dangerous drug, or over-the-counter medication that, when taken in quantities exceeding the recommended dosage, can result in impairment of judgment or reflexes. So, I guess we have to focus on how that's read. Does that qualification, where it says medication that, does that refer only to what follows, or does it refer to any controlled substance? That's what we're talking about.
I believe it refers only to what follows, Your Honor. And what would make me argue that is the case of Ohio v. Richardson,
Okay.
which is 2016, Ohio 8448. And that case is the one that's particularly controlling and on point in this because it discusses the issue of a substance that would be considered a controlled substance under hydrocodone. And that's similar to the methadone situation that we have here. In that case, the court held that the state had presented sufficient evidence to prove that that defendant had just ingested the hydrocodone. And then the court further went on in paragraph 18 to state that there was sufficient evidence to impairment based on the officer's observations on the scene. And the court ultimately in that ruling held that when the effects of a drug are sufficiently well known, as they are in hydrocodone, expert testimony leading to ingestion of a drug with indica of impairment is unnecessary, as there was lay witness testimony that consents impairment to the hydrocodone, i.e. the testimony of an experienced, well-trained officer. On these facts, we hold that the evidence was sufficient to support Richardson's OVI conviction. The state would argue that that connects exactly to this case in the arguments in regards to drug of abuse and impairment, and that those are similar to the facts of this case. You have a substance, methadone, that is labeled as a controlled substance. Controlled substance is listed as a drug of abuse in the code section that you cited. And based on that, 4506.01 subsection M definition of drug of abuse, it falls under controlled substance. There's been more than sufficient evidence or testimony that has been submitted to this court that would establish the two things that are required under Richardson. One, that the drug was in fact ingested, and actually it's three things. The drug was ingested. There's no question that the defendant ingested methadone. There's been numerous testimony. There was video of him ingesting methadone.
There also was a blood test to confirm.
Correct. Two, that there was expert testimony linking the injection to impairment. Wasn't even necessary under Richardson, but in this case, you actually have testimony from the lay people on the scene. I believe there were about 3 or 4 witnesses who testified to their observations and concerns in regards to the defendant's impairment based on their observations, not even knowing what was in his system. And then you had the extensive testimony from Lieutenant Gable as to his observation of the defendant throughout his time reviewing him on the scene, that he in fact believed he was impaired. So that in conjunction with the fact that he ingested the methadone, there was no disputing whether or not he ingested that. It's in his system. The code sections clearly define methadone as a drug of abuse since it is a controlled substance under 3719.41, Your Honor. So the state believes there's more than sufficient information here to show that methadone is a drug of abuse based on its categorization as a controlled substance. And furthermore, to the Richardson case, there's more than enough information to send it back to the jury, Your Honor.
What was the, it was 2016 Ohio what?
Ohio 8448.
All right, and looking at the definition of dangerous drug under 4729.01F, 1B, it says, under Chapter 3719 of the revised code, which is where methadone is found, that the drug may be dispensed only upon a prescription. So again, I'm looking at whether the phrase, when taken in quantities exceeding the recommended dosage, can result in impairment of judgment or reflexes. Does that modifier relate to over-the-counter medication, or does it relate to controlled substance, dangerous drug, and or over-the-counter medication?
It would be the defense's position, Your Honor, that it relates to all three. I think a plain reading of that statute indicates it relates to all three.
Well,
Well,
that's why I asked the parties to see if they had any, not just argue it, but support it. So do you have support for that? Is there a case that has considered this issue?
I do not know that there's a case to consider that issue, Your Honor. What I would say is that I had a chance to look at the case they cited. In that case, it can be distinguished from this case. One, in that case, Vicodin is a well-known drug of abuse. The court kind of relied on that, saying that Vicodin is just a well-known drug of abuse. There's been no testimony whatsoever that methadone is a drug of abuse. In fact, the testimony has been contrary to that by the medical testimony that methadone is not a drug of abuse. Dr. DeFranco said that it's not a drug of impairment. It doesn't cause impairment. When you look back at the case that the state cited, that individual had many, many indicators of impairment that the court thought were relevant. The fact was, he failed all the field sobriety tests, he was stumbling, he was slurring his words. That, in combination with the well-known effects of Vicodin, led them to believe that there was enough evidence to send that to the jury. That's different in this case. There's no indications, or not nearly the amount of indications of impairment in this case. There's no medical
Impairment
testimony.
is a separate issue. That's whether he's under the influence. We're just dealing with, is methadone here a drug of abuse? That's the only issue we're dealing with. Because there is sufficient evidence from the testimony of the trooper that, in his opinion, Mr. Gaspar was under the influence. There was some corroborating evidence from others that a jury could find supported that contention or that belief.
Well, then it's going to fall on our interpretation of that very narrow definition. I would say the rules of construction would imply that, yes, Your Honor, that caveat or that qualifier is necessary. There's been no testimony that this drug was given an amount greater than the recommended dosage or an amount that was likely to cause influence.
One or both of you can respond.
Judge, I would direct the court's attention to the testimony of Dr. DeFranco. I know it was long and tedious and filled with the black box warning language in which he agreed with the black and white of the pharmacology warning that when you have someone break their treatment by being non-compliant, even though you've previously reached a tolerance of an administered dose, when you begin to lose tolerance, you then fall into the dose initiation warning. The dose initiation warning Dr. DeFranco testified to was applicable where a person could suffer the initial side effects of impaired judgment, slowed reflexes, euphoria, sedation, and all of those things. There is evidence before this court and this jury that the defendant was non-compliant with his course of treatment. To say, arguendo, that you can have a prescription for an opioid and that because a doctor prescribed it, you're immunized under the law from all effects that might flow from your misuse of the treatment program is wrong and it's unjust. Here you have someone who has departed from his physician's care, he was absent, and then the dose was increased. The totality of the evidence is that he should have received a decreased dose or become stabilized. Dr. DeFranco admitted that it takes 5 to 6 days of continuation of dosing after a break to establish stability, which then takes additional time to then follow the black box warning of dose titration so that you can have established medically that the person is tolerating the dose at the newly established level. That is lacking here. And the defendant's absent from the clinic on the 10th and the 11th, so he's not in compliance with his physician's care. So he is, per se, abusing his right to the prescription.
The statute says it has to be taken in quantities exceeding the recommended dosage.
Your Honor, what the statute actually says I agree, the statute does say that, but I think we're trying to break the statute up when necessarily that's not what should happen. What it says is drug of abuse means any controlled substance, comma, dangerous drug as defined in section 4729.01 of the revised code, or, comma, or over-the-counter medication that, comma, when taken in quantities exceeding the recommended dose. The way that verbiage is set up can lead the reader to understand that that is talking about the over-the-counter medication. It's talking about when the over-the-counter medication is taken in doses exceeding the recommended dosage. And we can make that inference and understand, Your Honor, when we flip to the other statutes that you define, because those don't talk about necessarily there being a recommended dosage. It talks about the actual warning label that has to be on there telling someone, hey, this is the dosage you should take. So the state continues to assert the fact that that additional language is something separate and apart to the underlying language. And then we go back to the case law, which supports the state's contention on that. And what the court actually said was, when the effects of a drug are sufficiently well known, as they are with hydrocodone. Well, how do we know in this case that the facts or the effects of methadone are sufficiently well known? You had numerous witnesses who came in here and testified. They weren't methadone experts, they were just regular people in the medical profession. And whenever defense counsel began to inquire of them whether or not they knew the side effects of methadone, each and every one of them did. That can be taken as a drug that's sufficiently well known, or the side effects are sufficiently well known, Your Honor.
Mr. Sen, Ms. Knox, anything?
No, Your Honor.
All right, I'm going to go look at the Richardson case and see if there are any other cases I think are relevant before I look further at this issue. Any other counts that you have a different argument than you had on Friday?
No, sir.
And any additional argument on other counts for the state?
The state would incorporate its first Rule 29 argument into this argument, in addition to what we've stated.
Thank you. All right, so I've had a chance to go back and reread State versus Richardson, and I stopped there because it is a recent Supreme Court decision from December 29, 2016, and I'm not aware of anything more recent. The parties haven't presented anything more recent. And paragraph 14 seems to be dispositive of the issues that the court raised. And that was the statutory interpretation of this phrase, 4506.01M, drug of abuse. So in paragraph 14 in Richardson, the Supreme Court references that. They give the definition of drug of abuse. Then they refer to and quote the section specifically means any controlled substance, dangerous drug as defined in section 4729.01 of the revised code, or over-the-counter medication that, when taken in quantities exceeding the recommended dosage, can result in impairment of judgment or reflexes. Then they go on to talk about 4729.01F, and they also cite to revised codes section 371941 that puts hydrocodone in the Schedule 2 list. Then their comment, or their holding is, still for our purposes, those statutes say one thing, hydrocodone is a drug of abuse. So the fact that hydrocodone was a controlled substance and also fit into dangerous drug, for them seemed to be dispositive of the issue of what constitutes a drug of abuse. And we're in the same situation here. Methadone is a Schedule II drug. It's a controlled substance. So I think I'm constrained by the Supreme Court's decision, guided and constrained. So count 5 then will be amended so that it reads, did operate any vehicle, streetcar, or trackless trolley within the state, but at the time of the operation was under the influence of a drug of abuse, to wit methadone. I think that that's what the present state of Ohio law is. So the motion for judgment of acquittal on Rule 29 on that narrow issue that we talked about is denied, and it's also denied on counts 1 and 3 then because they require an underlying finding of driving under the influence.
Respectfully note my objection, sir.
Yes, thank you. And it's an issue that they dispose of in one paragraph, and at some point they may review that section differently. I don't know, but that's how they've read it most recently in the Ohio Supreme Court. Any argument upon anything, any of the other counsel that I'd asked you, but anything you thought of while I've been out?
No, Your Honor.
All right, so Rule 29 then, as renewed, is denied as to counts 1, 2, 3, 4, 5, 6, 7, 8, 9, and 10. Now the state was going to consider whether they were going to consolidate counts.
Judge, at this time, we agree with the court's prior, if you will, suggestion or observation that counts 3 and 4 are unnecessarily duplicative, and we would withdraw them or dismiss them at this time so that the jury is not unnecessarily confused by repeat counts, if you will, the difference being the furthermore. Our primary concern, though, is that the instructions of the jury adequately apprise them, as I think it already does and the court will instruct, that a finding of guilt on the base offense without a finding of the furthermore does not negate a conviction. It's just the element of the furthermore that needs to be established that distinguishes it from the other parallel counts. That is the state's concern, so that so long as that is made clear to the jury, we agree that they're duplicative.
Any objections to the state asking the court to dismiss counts 3 and 4?
No.
To reiterate, counts 1 and 2 contain all the allegations in counts 3 and 4, but they also contain an additional further finding that the jury would have to make a decision upon that would enhance the potential penalty. So they're the same charge, but with an enhancement. All right, so upon the motion of the state without objection, counts 3 and 4 are dismissed. So then you're going to be going forward counts 1, 2, 5, 6, 7, 8, 9, and 10. I have a revised jury charge. It has not incorporated the just decided issue on counts 3 and 4, but otherwise I ask you to look at it. Mary is going to lunch. Whatever changes you have, Diane can make. She's back from lunch. And then when we come back, 2:40, 2:45. We'll be back here at 2:45. If the jury charge is acceptable, you can argue, and then challenge the jury.
You want to talk about lesser included request? Or,
Well, that's the kind of thing I would have expected to have been brought up earlier. But go ahead, what's your request?
I am requesting a charge of negligence, particular assault, based on the current state of the evidence, either as a lesser included offense or an offense of an inferior degree.
Judge, I know the court recalls the old issue of whether you can get there from here, as they say, or you can't get there from here, as they say in Vermont. The issue of lesser included versus inferior, and whether the elements are dissimilar, or there's an additional element. I don't believe that there is a path. I could be wrong, but I don't believe that the issue of negligence can be derived.
Perhaps we could take a short break, Your Honor, on the law on that, or do it right now. Well, nuclear manslaughter is probably what I'm looking at. 47. 1 second, Your Honor. I think you're correct when I said I'm looking for vehicular manslaughter.
I'll come back, look it up further.
I got it.
Well, no.
Sure.
Mary can't stay here all day.
Vehicular homicide 2903-0683. So operating,
Mr. Sen,
sorry, Your Honor.
it's 2 o'clock. I'm sending her to lunch.
That's correct.
And you can talk with me about that. Mr. Thompson can talk with me informally about it. And then I can make a decision on it, and it can be put on the record later. Okay? Yep. So I'll see you back here at 2:45. Well, I'll see Mary back here at 2:45. You all aren't going anywhere right this moment. Thanks.
Thank you.
Did you name me?
Better? All right, so we're back. Back in the record, in case 614-979, State versus Joshua Gaspar, we were talking about possible lesser included that were requested. The parties ever reach any consensus as to what's allowed, not allowed, what the penalties are, other ramifications? And I will remind both sides, but especially the defense, since you brought this up so that's a late time. I asked you last week if anybody had anything special, because we could have prepared alternative versions of this, and my jury wouldn't be sitting downstairs now. But
We have not got a chance to review our findings with the defense, Your Honor, but it would be the state's position that the negligent would be a lesser included of the reckless,
Count
but
two.
not count two, but not of the OBI count one. However, while the peace officer specification would not apply to the lesser included, the furthermore specification of a suspended license would still apply to the lesser included of count two, still making that a felony in the fourth degree, if the furthermore is found by the jury.
my thought would be that I would leave them with that. Well, I would have to adjust the jury verdict forms, because I don't think that 5-year spec applies to vehicular manslaughter, because it's a negligence.
Correct.
I agree with you. I think that's a misdemeanor 1 without the furthermore, and a felony 4 with it. Is that correct understanding? That's my
Yes.
understanding.
So, you vacillated a little bit earlier. What do you want on behalf of your client?
Have a moment.
Yes.
Thank you.
Good, we are making that request for that lesser included.
So on count 2, you want an instruction on a lesser included, which in this instance would be vehicular manslaughter, misdemeanor in the first degree, but if the further finding is found that your client didn't have a valid license, it would be a felony 4.
Correct.
Is that your understanding of potential penalties as well?
Yes, Your Honor, it is.
All right, so count 2, I'll work with the secretary, and we'll try and come up with the appropriate language, including the state of mental state of mind, negligence, and a different verdict form. Any other counts or any other instructions that are being requested? You've all had a chance to view the revised proposed jury charge.
Your Honor, I was going to note some changes. Some of them are just grammatical. On the page it says reasonable doubt, instead of putting in quotation marks, they wrote the word out, quote.
Well, I think it's run that way for 10 years. I don't think a jury's been confused, but I'll leave that one in.
Okay. There is a piece for defendant's testimony. The defendant didn't testify. So.
I will pull that out.
And then this independent intervening cause of death and intervening causes, that's not applicable in this case, I don't believe. It's under natural consequences. It's the last two on that page.
Just having you see what they're asking the court to delete. It's under the first count.
Okay.
On the page it starts out natural consequences, then other causes not an offense. State's asking the court to delete where it talks about intervening causes. And also independent intervening cause of death.
You want to take out natural consequences?
No.
No, okay. Intervening causes.
Although I'm not sure I would take out the intervening clause
I-
because the defense has questioned about someone slamming on their brakes and such.
I agree.
I think the intervening cause stays in. Independent intervening cause of death, I could see that only applying if, for instance, another car had struck Trooper Velez or something like that. I don't know that there's any other reason for it to then be in this particular case.
I agree, Your Honor.
So the charge, proposed charge for the definition of independent intervening cause of death will be removed.
And, Blaise and Quinn are talking right now, but that's all I have.
Judge, the issue that we're discussing amongst ourselves is a request for a instruction based in part on Richardson that the state is only required to meet that standard there, that proof of ingestion and observations are sufficient. You don't have to provide expert testimony, which is, I think, the distillation of Richardson.
Richardson is the case I gave all of you a long time ago, right?
Correct.
There was a motion to suppress that had been filed.
It's the December of 16 Supreme Court of Ohio case.
I don't know that OJI has revised this section yet.
I understand, but that's why I'm bringing it up. So if Richardson is new authority subsequent to whatever's in OJI, we would ask the court to amend OJI or reflect Richardson.
I don't see anything in the definition that we have in there for under the influence that says that there has to be expert testimony. Do you all have that? It's under count 5 on the page. It starts at the top right of the view. I do have one change that I think is required. We talked about drug abuse as a definition And OJI has a comment under CR 711.19, page 450 of our 2008 revision. The comment says the classification of a particular substance as a drug of abuse is a question of law. The identity of a particular substance, whether or not the defendant has ingested it, and the effect, if any, upon him are questions of fact. So the drug of abuse, then that would suggest that I can instruct the jury that you are instructed that methadone is a controlled substance under Schedule 2 of the revised code and is considered a drug of abuse.
Yes.
And that's what the case law suggests.
And that's what the court pointed to the language of Richardson.
All right, so I'll amend or revise that definition of drug of abuse to include that additional language. But the issue of under the influence you're all looking at now, it doesn't say anything about expert testimony. And we previously had discussed the fact that there was no alcohol alleged to have been involved here, so I think I'm going to take that out of the definition here of under the influence. I don't want them to speculate that there could have been something in there, because there is no evidence on that point, correct?
Correct, Your Honor.
Yes, Your Honor.
Thomas is still mulling it over, but I didn't hear any of your report.
Well, I was just examining whether the layperson's testimony as to what they observed, but I know that there's no blood analysis.
Or urine, or
urine, yes, I know.
no, there's no beer or other bottled spirits in the car. I mean, it's just not there.
You don't have another issue with language?
Hold on, sir. Yes.
Thank you, Your Honor. With respect to the driving under suspension language as it's contained in both the count 1 and count 3, and then also the driver's license language in count 5, given that we've had testimony about different states and different licenses, Your Honor, the only thing relevant to this court is whether my client has an Ohio driver's license or the Ohio revised code was violated.
That's what you say.
It is what I say. And
That's not what I heard from testimony. And that's not what I'm ruling.
Tell me.
Because your client, the lady said that he's asked the question about whether he's under suspension in another state. And if he was untruthful about that or inaccurate, he would. If he had told them they didn't have a license in another state, he wouldn't have gotten past that initial point. But if he's inaccurate about it or untruthful, that's a jury question as to whether.
And I agree with you as to tampering charge, but as I look at the language, Your Honor, on the further finding. If the verdict is guilty, you must decide whether the defendant was driving under suspension or cancellation imposed or was operating a motor vehicle or motorcycle, did not have a valid driver's license, commercial driver's license, temporary construction permit. Is it the court's position that if he did not have a valid Alabama license or he did not have a valid Alabama...
That's what the interstate compact is for, as I understood it through the testimony.
Perhaps, but the only violation of Ohio law is whether he didn't have an Ohio license. He wouldn't be in violation of this law if he didn't have an Alabama license, was driving under a suspended Alabama license. That's my position. I mean, I get what the interstate compact has been testimony on it, but as far as a finding by the jury, can they find this specification if they say, well, he had an Ohio license, perfectly valid, but he did have a suspended Alabama license, therefore, I think that would be inconsistent.
You know, if they believe the evidence that your client obtained the license because he didn't fully disclose, then they can determine that he shouldn't have had an Ohio license. And I know that you keep calling a valid license. They'll decide if it was a valid license. And if he wasn't allowed to have one in Alabama and couldn't have one in Ohio, then they can find that he's driving under suspension or without a valid license.
How about the language of the state
I
council?
will mention this stuff. I'll have a very neutral statement to the jury. When you made your opening, you represented that or through question, you represented to a witness that your client had gone to and gotten information about this and that. He didn't testify, so you may not rely upon that information in your closing, and the jury can't rely upon it either. They can't rely upon statements that the state made that weren't supported, okay?
Yes.
So.
You got it now to focus on count two. It's kind of the same argument. There's a furthermore, at the time of the offense, the defendant was driving under suspension or cancellation opposed under Chapter 4510 or any other provision of the revised code. That clearly should be Ohio revised code. There's no reason to mislead the jury to think that if he's driving under a violation of the Alabama revised code, there's nothing wrong with referencing Ohio revised code Chapter 4510.
I can put Ohio in there if that will resolve things.
And what your both in chapter and no, Ohio would be great, right?
Anything else?
Not a mistake.
Senator, anything?
No, Your Honor. Thanks, sir.
All right, so the bailiff is checking down with our jurors who've been downstairs all day to see how they're holding up. I'm going to work with Diane and try and get the rest of this done because, of course, counts 3 and 4 are out. There's other changes. See whether we can even have argument in charge today. Thanks. Diane is working on the changes that have been proposed. you don't really need him
I'm
here for
telling
this.
Okay, all right.
Although he may want to be here because the jury's going to come in a second. In the event, Diane's working on the changes that were proposed to conform to what we talked about in court. So I'll be working with her. It's about 4:15, 4:20. I would like the parties to remain here so that you can review the next draft of this so that tomorrow morning when we come in, there are no surprises and the jury can, in an orderly fashion, hear your arguments, focus on the jury instructions, and then proceed to deliberate. That's my goal. So they've been very patient with us today, and I don't want to cause them to have a lack of concentration. Mr. Sincom?
Yes.
What time would you expect to start in the morning?
I'm going to have them here at 9:15. I expect that all of you are going to talk at length. The part I have, the jury charge is probably 45 minutes or so, but I expect that you will be talking longer than that. So if we have them here at 9:15, and then I can start somewhere around 9:30, that gives you ample time to succinctly state your case.
He said he's here. Yes.
When the jury comes in, I'm going to have you tell them that you're going to stand up and say that you rest, and ask them to state if they have any rebuttal. They're going to say no, and then I'll tell the jury what our plan is for the next day.
Everyone else, please.
Mr. Thomas, you wanted to explain to them about the cell phone.
Yeah.
So you can do that, and then I'll turn to Mr. Sen, and then we'll proceed.
Cell phone, talking about what we showed.
All rise for the jury. Court is in session. Please be seated.
Good afternoon, everyone. Welcome back. Thank you for your patience. There have been times today where probably all of us envied you to be down on the 4th floor, okay, instead of here. But we've been working through issues with the attorneys in terms of the evidence and the case and everything else in order to focus it a little bit for you, for your consideration in the future. Mr. Thomas?
Thank you, Judge. With the court's permission, ladies and gentlemen of the jury, there was an additional state's exhibit that was stipulated on to the record but not presented in front of you. So as a housekeeping matter, you should understand that state's exhibit 1625 is a stipulated record from AT&T of the defendant Joshua Gaspar's cell phone activity on the day of the 15th. And we'll be talking to you about that in closing argument. And that the defense agrees that that's a stipulated exhibit. Correct?
Thank you. Mr. Thomas, that is a little bit of an addendum to the state resting the other day.
Correct, Your Honor. And with the court's permission.
And, ladies and gentlemen, you did hear testimony from a defense witness who was taken out of order for convenience and necessity. Mr. Sen, what's the state of evidence with respect to your client?
Your Honor, at this time, the defense would rest on the burden of proof, sir.
All right, so you've now heard all the evidence. You're going to hear from the defense. And again, as I told you at the outset, the defendant doesn't have to testify. The defense has no burden. In the case of Mr. Gaspar, in his situation, you may not consider his the fact that he doesn't testify for any reason whatsoever. Okay? The state has the burden of proof. On behalf of the state, what about any rebuttal evidence?
We have none, Your Honor. Thank you.
So, ladies and gentlemen, you have heard all the evidence that you're going to hear in this matter. The next portion of the proceeding will be the arguments of counsel and then the jury charge. But I can't do that to you today because it would extend far past 4:30. You've already been patient. And I'm still working, when you came up, I was working with Diane on some edits that the parties had suggested to the court and some things that I had wanted to include there. So we have, they're going to be here working until we're done. But you can be back at 9:15 tomorrow morning. So what I anticipate is Mrs. Smith will call you up for 9:30. We'll have the closing arguments, the jury charge, and then you can begin to deliberate on this matter. All right? So again, alternates, you remain with us throughout. Alternate. You remain with us throughout because your service may be required. But keep in mind, you may not discuss this case among yourselves or with anyone else. Don't let anyone discuss the case with you or in your presence. Don't form or express any opinion. No media accounts, no investigation. But we are getting to the part where we have asked you to help us, and you'll put to use some of the tools that we'll give you by way of jury instruction as well as your own observations from witnesses. Okay, so tomorrow you'll have the closing arguments and the charge. Again, I know you were downstairs a long time today. It may not seem that was helpful to us, but it was because, again, you're here to help us resolve a dispute. We appreciate your willingness to serve greatly. So thank you all.
All rise.
So Diane's making the changes, and probably in about 10 or 15 minutes she'll have a copy for you to review. And we will get that nailed down before we go home. One other thing I wanted to say, you had already removed the Rule 29 motion, so the arguments and all stand, and the court's ruling stands. I've denied Rule 29 as to all counts as they existed after the state asked the court to dismiss counts 3 and 4. And again, it's under State versus Bridgman as well as the State versus Simmons that the court's relevant inquiry is whether, after viewing the evidence in the light most favorable to the prosecution, any rational trier of fact could have found the essential elements of the crime proven beyond a reasonable doubt. I think the state has met that burden for purposes of the renewed Rule 29 on all those counts. Thank you.
Thank you, waiting here for this. We'll wait around and we'll be ready to talk in a few minutes.
Or you could wander off and Candace will find you.
Okay, Your Honor. Thank you.
Either way.